Hello friends, today we continue to add to our series, Everyone You Love and Everything You Have. Continuing with our concerns about the ways in which wills fall short of estate planning goals. Wills are fully public. I remember very well that when Jacqueline Kennedy Onassis passed away, within days of her death, sections of her will were published on the internet. This is because the will is a public document. When submitted to the probate court, someone simply went to the probate court and used a hand scanner to put portions of her will into the public eye. I remember studying for the bar. This issue came up, and my wife was aghast that someone would be able to see what our daughters received, the inventory of the estate, and that an unscrupulous person might try and take advantage of them. Wills don't provide against living probate. If I am incapacitated and there is not other planning in place, we may have to have a conservatorship, which is essentially a living probate or guardianship to manage and control my property and affairs, and a guardianship to control my person. Wills are very easy to challenge. In fact, we are required to send notification to all heirs at law, regardless of whether they have been named in the will as a beneficiary. So if there's a particular person I do not want to receive assets, I can exclude them from my will. But if they are an heir at law, they may receive notice of my passing and an opportunity to step forward to the probate court and make a complaint, or to ask that the person I've named in my will not be named as executor, etc. And so it's very, very easy to challenge a will when it is being probated. Wills, by their definition, contain sterile legalese, and even worse is the probate process. The probate forms are difficult for the layperson to understand. Even in jurisdictions that have tried to improve this system, there is legalese, there are archaic terms that are just plain confusing and difficult for the layperson to understand. And our will do not cross state lines well. Unlike a trust that is going to be recognized in all 50 states, each state's probate system is different. Certain state probate provisions are should often be included in the will, and so when we move from one state to another, the will is one of those documents that really should be reviewed by a professional, and assure that the will and your wishes expressed in the will will be effective under that state's law. So unlike trusts, the will does not cross state lines well. For all of these reasons, wills being fully public, not protecting against incapacity or conservatorships, what we call living probate, the ease with which they can be challenged, and the cumbersomeness of probate and legalese and forms, as well as the fact that they do not cross state lines well, all mean that wills often fall short of our clients' estate planning goals.
Until then, take care of yourself, take care of your family, and take care of your clients.